In 1902, the shooting of Town Sheriff James Cockrill took place in Breathitt County, but his death would happen in Fayette County. 3 years later, after this fact, in 1905, the Hargis faction would begin the first of their criminal trials to determine the guilt or innocence of those accused. The Commonwealth of Kentucky was still working under some of the statutes that were given under the reign of King Edward VI of England, 1547 through 1553. King Edward VI was born in 1537 and became king at the age of 10 years old. One of his statutes would cause a lot of drama in 1905. Come along with us as we watch how this case would make it through the Kentucky State Court of Appeals before the first witness would ever be called. What would the appellate court say about the fight for the jurisdiction, and who would win the battle? All aboard the Kentucky-Tennessee Living Time Machine. Please fasten your seatbelts and keep your arms and legs inside of the vehicle at all times. But to get going, we need your help. We still need to fire up that time machine to transport us. Please help us by clicking on the like, subscribe, and bell notification buttons down below. Not only does this fire up the time machine, but it convinces the YouTube algorithm that we need a bigger time machine to reach more people who love history as much as you do. Now, back to our story. Indictment for murder of James Cockrill. It seems that the convictions of those who actually pulled the triggers, a huge damage case, and several trials for contempt of court did not end the troubles for the Hargis faction. Now, they would find themselves indicted for the murder of James Cockrill by a special grand jury in Fayette County. This would be the first of 4 murder trials to come. Please bear in mind that all of the previous testimonies will be used in these trials, and we will only cover new testimonies concerning this topic. Please refer to the Markham damage case, the Bridgeton trial, and other Breathitt County criminal cases if you have not done so already. There were several separate newspaper accounts. Each one of them gives a little more detail about what happened when it came to the grand jury indictment of the men accused of the conspiracy to kill James Cockrill. According to the semi-weekly Interior Journal, written on January 27, 1905, quote, the Fayette County Special Grand Jury has returned indictments against James Hargis, Alex Hargis, Elbert Hargis, Ed Callahan, and Jesse Spicer, charging them with conspiracy to murder James Cockrill, town marshal of Jackson, who was killed July 1902. Bench warrants have been issued for the arrest of all indicted men, unquote. So, in the first article, we get where the special grand jury took place, who was charged, what the charges were, and that the bench warrants were issued. We get far more information in the second article that came out the same day by a different newspaper. According to the Bourbon News, written on January 27, 1905, quote, indictment of Breathitt men. The grand jury of Fayette County has indicted Judge James Hargis, county judge of Breathitt County, Ed Callahan, sheriff of that county, Alexander Hargis, ex-senator from the senatorial district, Elbert Hargis, brother of the county judge and ex-senator, and Jesse Spicer, a deputy sheriff under Sheriff Callahan, for conspiring to kill James Cockrill, city marshal of Jackson, who was shot from the courthouse window in Jackson over 2 years ago. The indictment is found by the grand jury of Fayette under the statute of Edward VI, giving jurisdiction to a court in either the county in which the crime was begun or in which it was finished. James Cockrill was shot in Breathitt County, where the conspiracy, if there was a conspiracy, was formed and the crime begun, and died in Fayette County, so under the statute the court in either county had jurisdiction. William Britton is now on trial in Fayette Circuit Court, is, as far as we know, the first man who has ever been indicted and tried under the statute. We kept scratching our heads on this one. Didn't James Cockrill die in front of the courthouse? Well, as it turns out, he didn't. In fact, he was transported to Lexington before he died. According to the Mount Sterling Advocate article printed on February 1st, 1905, quote, The indictments. The indictments are found under Old English law, which provides that either courts of the county in which the crime is begun or consummated have jurisdiction. The law has recently been sustained in the Barber case in Louisville, which is similar in all respects to the Cockrill case. Cockrill was shot in Jackson, but he was hurried to a Lexington hospital where he died the next day. The Breathitt grand jury failed to indict, and through the efforts of A. Floyd Byrd, former Commonwealth's attorney of Breathitt, the matter was brought to the attention of the Fayette Circuit Court, and the indictment followed. Unquote. So, in order to bring these charges, the prosecuting attorney in the case, A. Floyd Byrd, would look back through the books to see how charges could be brought against the men. A way was found in the case of James Cockrill. Because he was shot in front of the courthouse in Jackson, which sat in Breathitt County, and the fact that he was transported to Fayette County where he died. This opened the door for Fayette County to bring charges against the men for this act. But getting the men to trial would be more of an issue than would be expected. Attempted arrests. The bench warrants had been issued. They were handed to Walter Marshall, chief of detectives, to carry out. However, it would not be an easy endeavor for him to accomplish this, and now the fight between the counties would begin. According to the Bourbon News, written on January 27, 1905, quote, later report, Chief of Detectives Walter Marshall went to Jackson with bench warrants to arrest 5 men indicted. Upon his arrival, there found that the Jackson magistrate had issued warrants against them and refused to let the marshal have the prisoners. He wired back to the officers of Fayette County Court and received the following reply. Quote, Breathitt County warrants should not prevent you in serving the warrants you have. Arrest the men if possible without bloodshed, or report to this court why you could not have served the warrants. Unquote. The supposition is that the Breathitt County warrants were hurriedly prepared and served in order to head off the Fayette officers and prevent that court from taking jurisdiction of the case. Unquote. This is what we have learned so far. Chief of Detective Walter Marshall went to serve the bench warrants on the indicted men. When he got there, he found out that there had been a rush to serve the men with Breathitt County warrants by the Jackson magistrate, and he also refused to let the men go into the custody of the chief, as they were already in Breathitt County Jail. After speaking to the magistrate, Chief Marshall contacted the judge by telegraph, to which he was told the men are to be taken into his custody, preferably without bloodshed. But it must be done regardless, or else he would have to answer to the judge as to why this could not be accomplished. We can say that the men were not moved out of the jail at this point until after the Court of Appeals had their ruling about who had jurisdiction. In next week's video, we will dig into the case before the Kentucky Court of Appeals and how they would rule upon the matter, and if the men would face trial in Breathitt or Fayette County. Thank you. We at Kentucky Tennessee Living would like to thank you for watching our video series on the Appalachian feuds. Don't forget to hit that like button, as the more likes we receive, the more likely YouTube is to suggest our videos to other viewers. Also, to receive notice when we upload a new video, be sure to subscribe and click the bell notification button. We thank you for continuing to support Kentucky Tennessee Living as we are discovering the mysteries in Appalachian history.